Major breaking news, a big win for the Second Amendment in, believe it or not, the United States Court of Appeals for the First Circuit out of Boston. Oh my God, you never hear such a thing. Let's talk about this huge win for the Second Amendment in a place that we never, ever, ever, ever win in Boston. Let's talk about it. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, so this is a big deal. The United States Court of Appeals for the First Circuit, America's worst anti-gun court by far, so bad that the government of Mexico, when they decided to sue the American gun industry, said, where do we want to sue the American gun industry and have the best chances to win for Mexico? The answer is Boston. And that's exactly where they sued. Well, believe it or not, today, folks, we had great news, shockingly so, out of Boston. The U.S. Court of Appeals for the First Circuit actually said that a lower court decision that had been entered in favor of the Second Amendment, shutting down Maine's 72-hour waiting period, could continue, meaning the injunction shutting down the gun control law of Maine that said you could not take possession of a firearm after buying it for 72 hours. The First Circuit Court of Appeals basically said, yeah, we're going to let that injunction of that gun control law in Maine stand. We're going to agree with the district court for now that Maine may not enforce that waiting period of 72 hours. We're on board, for the moment at least. Just to jog your memory, in the case of Beckwith versus Fry, Trump-appointed Judge Lance Walker entered an injunction a couple months ago, finding that Maine's 72-hour waiting period, which was a gun control law they recently enacted that says even when you buy a gun from an FFL, you have to wait 72 hours before you can take possession of the gun. And if they give you the gun early, then the seller of the gun gets to pay very large fines. Well, a lawsuit was brought in the case of Beckwith versus Fry, and Judge Lance Walker entered a preliminary injunction, finding that this 72-hour waiting period almost certainly violated the Second Amendment, and therefore it should be enjoined, and Maine is not allowed to enforce it against the people in Maine, including the gun dealers in Maine. Well, the state of Maine wasn't very happy with this big loss to their gun control law, and they sought an immediate appeal to the U.S. Court of Appeals there in Boston, which covers the states of New Hampshire and Massachusetts and Rhode Island. And it turns out that the three-judge panel in this case, all three judges are appointed by or were appointed by President Joe Biden, or at least were appointed by his auto pen. I don't know. Anyway, this three-judge panel consisting of Joe Biden appointees actually said that they were not going to stay or stop the effect of this district court injunction in favor of the Second Amendment. Specifically, here's what the three-judge panel of Joe Biden appointees had to say specifically about the lawsuit and the appeal to begin with. Defendant appellant Aaron Fry, the Attorney General of Maine, has filed a motion to stay pending appeal a preliminary injunction that bars enforcement of a Maine statute that imposes a 72-hour waiting period for certain sales of firearms. In granting a preliminary injunction and denying a stay, the federal district court found that plaintiffs, consisting of a group of Maine citizens and business owners, including federally licensed firearms dealers, were likely to succeed on the merits of the Second Amendment challenge to the statute. The Attorney General of Maine argues that the district court erred in applying the standards set forth in Nicerva v. Bruin, and maintains that allowing the injunction to remain in effect pending the appeal here will result in irreparable injury to the state's interest in enforcing a duly enacted law, and also may result in a loss of life that could be avoided if the law were enforced. So that's a really nice setup about what the issue presented to the U.S. Court of Appeals for the First Circuit there. Those 3 Joe Biden appointees down there in Boston. One technically is in New Hampshire. One of the judges is actually a former prosecutor in New Hampshire, but we don't need to be finely detailed for the purposes of this discussion. And guess what they did? They said, yeah, we're not going to interfere with the district court judge's decision that enjoying that Maine gun control law, we're going to basically let the Second Amendment stand for at least the moment in the state of Maine. Here's what the First Circuit ruled. Here's what they wrote. Because this case presents questions of first impression in an emerging area of constitutional law involving a legal standard that is difficult to apply and subject to varying interpretations, we are not persuaded that the Attorney General has made a strong showing that he is likely to succeed in demonstrating that the district court abused its discretion in granting preliminary injunctive relief, and that the case does not present unusual circumstances involving a particularly severe and disproportionate harm to one side. Indeed, the Attorney General's failure to seek expedited review here of the stay motion or the appeal undercuts any claim that Maine might have for immediate relief from the injunction is required to prevent irreparable harm. Accordingly, we deny the request for a stay and reserve consideration of merits to the panel hearing this appeal. Great stuff. They basically said, look, we're not going to get involved. We think the district court did a reasonably good job here. We don't see any crazy reasons to think that he's wrong. So for the moment, we're not going to interfere with the preliminary injunction. We'll let this case play out. Now, of course, eventually the U.S. Court of Appeals for the First Circuit is going to have a panel. They're going to hear this whole case. They're going to hear all the briefing, and they're going to throw the Second Amendment under the bus. I just want you to understand how bad it is in the First Circuit. So for those of you in California, for those of you in Colorado, Washington, some of the, Maryland and Virginia, these are sort of, within the shadow of a lot of these other terrible anti-gun courts, to show you how terrible it really is. In the First Circuit there in Boston, New Hampshire, and Rhode Island, there is not a single, listen carefully, there is not a single judge on the U.S. Court of Appeals for the First Circuit who was appointed by a Republican president. There's no George H.W. Bush appointees. There's no Trump appointees. There's no George W. Bush appointees. They're all Democrats on the U.S. Court of Appeals for the First Circuit. It's terrible. There is no 3-judge panel that you can get that is good on the Second Amendment. And the fact that today we had this huge win, at least for the time being, for the Second Amendment out of that jurisdiction is really quite the miracle. So, again, maybe, just maybe, some of these lower court judges are starting to think more seriously about the Second Amendment and the actual precedent set forth by the Supreme Court. I'm not holding my breath, but I do got my fingers crossed. So anyway, the bottom line is this is a big win. And just to jog your memory about the rationale articulated by Judge Lance Walker there in Maine in entering the initial injunction, he basically said, look, if you read the text of the Second Amendment, the right of the people to keep and bear arms shall not be infringed. The right to keep means to possess. The right to bear means to carry. Obviously, the only way you can possess an arm or carry an arm is you got to acquire it in the first place. Virtually everyone in America acquires their guns from buying them from a gun store. Like we go to a restaurant, we go to a supermarket, you buy stuff at stores. It's kind of how commercial commerce works in America, right? You can make your own gun. You can, farm your own farm, right? You can do your own fields, but the reality is most people buy stuff from stores, and that includes guns and ammo as well. And Judge Walker said it's pretty clear that it's a concomitant right, it's an ancillary right to the right of the people to keep and bear arms, that you have the right to acquire it, and that includes the right to buy it. So if you have a 72-hour delay mandated on everyone that acquires a gun from an FFL in Maine, you are undeniably hindering the right to keep and bear arms because you're delaying the ability of someone to get a gun, carry a gun, have a gun for 72 hours. And if you want to draw an analogy, if someone says, I want to post something today on X, or I want to give a speech at the town hall today, but I'm forced by law to wait 72 hours before I'm allowed to hit send on that email, to publish the op-ed, to give the speech, to post something on X or Facebook, or which is now Meta, I guess, right? Then guess what? That clearly would violate the First Amendment. So the reality is that this is pretty obvious. This should be a very winnable case. And that is exactly what Judge Walker said, that this is clearly textually an infringement on the right to keep and bear arms. And because of that, the burden shifts, as you know, to the government to do what? To show there's some sort of a long-standing, going back to the time of the founding, historical record of laws that somehow are analogous to the modern-day gun-related restriction. The example I always give is we know that you cannot use a firearm to commit cold-blooded murder, and that question is whether or not you have the right to commit cold-blooded murder is not answered by the text of the Second Amendment. How exactly is that answered? We know how it's answered. You have to look at the history of America and the United States, and obviously there is no right to commit cold-blooded murder. You could go to prison the whole time, before the Revolution, after the Revolution, during the founding, up to now. That's an example of a long-standing gun-related restriction. You can't use a gun to commit cold-blooded murder. That would be an exception to the textual right of the people to keep and bear arms. And likewise, what Judge Walker said here is there's simply no example whatsoever in either the 18th century or even the 19th century of any kind of delays required by law before you can take possession of a firearm after you buy one. You don't start to see any conceptual anything that might be somewhat analogous in any respect to a waiting period until you get, well into the 20th century, which the Supreme Court has said repeatedly, 20th century case law, 20th century legal precedent is way too late to tell us anything about a historical exception to the text of the Second Amendment. And that is exactly what Judge Walker had to say in entering this injunction in favor of the Second Amendment, in favor of these gun dealers, in favor of these gun owners in the state of Maine and against the state of Maine. And basically the U.S. Court of Appeals today for the First Circuit sort of said, this all makes sense to us. We're not going to get involved. Maybe we'll change our minds down the road in many, many, many months after this argument and briefing and everything else. But for the moment, we're not getting involved. And that preliminary injunction shutting down Maine's ability to enforce that 72-hour waiting period, we're not interfering with it. That's going to continue, which means that preliminary injunction issued by Lance Walker, the judge, in February, continues onwards through the appeal through the U.S. Court of Appeals whenever that Court of Appeals will ultimately issue its ruling. So there you have it, folks. A bit of good news out of the Northeast of the United States. Make sure you follow me on X at @4boxofdiner. Don't forget to subscribe both to YouTube and Rumble. And I look forward to talking to all of you again very, very soon here at the 4 Boxes Diner.
Orders up. Table 2A.